Hello, I'm Frances Edwards and I'm a legal advisor at Family Rights Group. Over the past year, we have been paying close attention to the numbers of children being deprived of their liberty by the family court. It is a serious step to deprive a child of their liberty. It involves the state restricting their freedom in some way, and it often means a child is confined in a particular place, or their movements constrained and supervised in ways which are different to how you would expect a parent to care for a child of that age. There are two ways a child can be deprived of their liberty by the family court: either under a secure accommodation order, or an order made by the High Court using powers known as the inherent jurisdiction. This is a route now so frequently used, a bespoke court has been established to keep track of the applications. However it is done, depriving a child of their liberty is a draconian measure. It engages the child's right to liberty under Article 5 of the European Convention of Human Rights. It can have a significant impact on their mental and physical well-being and lead them to being isolated and subject to high levels of restraint. We also know that it can be difficult to secure an appropriate home for a child in these situations. Too often, this results in children living in settings which do not meet their needs and are far away from their families and communities, far from familiar people who might be able to offer them support and comfort during what is likely to be the scariest of times. Too often, parents and carers have no access to information and legal advice where their child is or may be deprived of their liberty. Where court applications are made, many are unrepresented, left to navigate confusing and distressing proceedings alone. Nuffield Family Justice Observatory found that in only 11.5% of applications made under the High Court's inherent jurisdiction were parents or carers legally represented for at least one hearing. Family Rights Group have recently published a briefing note which looks at legal aid provision where a child is or may be deprived of their liberty by the family court. Our note highlights that the regime is riddled with anomalies and injustices. For example, a parent whose child is subject to care proceedings is entitled to legal aid to fund advice and representation in those proceedings. This is not means tested and only a low merits test applies. The same cannot be said in relation to deprivation of liberty proceedings. Parents and carers' financial situation and a more stringent merits test will determine whether they receive legal aid. This restricts their access. Our note concludes with clear recommendations for reform. So why is this so important for children and families? Well, whether, where and how a child will be deprived of their liberty are questions without straightforward answers. The relevant law is complex and the potential consequences for the child and their family significant. Access to legal advice and representation, both before any court proceedings and during them, is vital so that families can understand what is happening and what their options are. It enables families and children to be involved in planning for the child, and it is also an important part of making sure fair process is followed for the child and family, both in and outside of court. At Family Rights Group, we are clear that urgent reform is needed to address these injustices in the current legal aid regime. We have put forward proposals to help children and families access legal advice and representation they so urgently need. And we are now inviting supporters to back our call by signing our joint letter to the Ministry of Justice. With the number of children subject to these applications continuing to rise, there is no time for delay.